live streaming on YouTube now. We can start. I'm sorry for
Would
this.
you want me to start all over again?
Yeah, I think it's better we start over again.
Okay.
We are exclusively having audience from the YouTube only.
Sure. Okay.
Thank you. Sorry for the inconvenience.
No problem. Okay, good evening, everyone, and welcome. Our topic for today is stories inside and outside the courtroom, death penalty in India. And I am going to be in conversation with Dr. Anup Surendranath about his work on the death penalty in India. In particular, we're going to be discussing a new book that has come out by HarperCollins called The Punished. The author of the book is Janvi Mishra, and this book tells the stories of death row prisoners in India. It is based on the work that Anup Surendranath and his team at Project 39A have been carrying out for quite some time. So we're going to be discussing the book, we're going to be discussing death penalty, we're going to be discussing the criminal justice system. We'll take about 20 minutes, we'll take about 40 minutes for a conversation between Anup and I, and then we will open up for questions. If you're on the Zoom platform, please use the Q&A feature to ask your questions. If you're on any other platform, use the chat feature on your platform to ask the questions, and our team will ensure that those questions are forwarded to us. So feel free to ask your question at any time. We will get to them in the last 20 minutes. So just to briefly introduce ourselves, I'm Aparna Chandra. I am an associate professor at the National Law School, Bangalore, and I teach constitutional law here. The other speaker for today is Anup Surendranath. Anup is the executive director at Project 39A at National Law University, Delhi. He's also an assistant professor at National Law University, Delhi. Okay, Anup, with that, let's get started. And in fact, I was saying before before we started that I'm very excited to be in conversation with you, because when we were colleagues at National Law University Delhi, I had a ringside view of the work that you and your team was doing, and I saw your work grow from a report on the death penalty, on which this book is based, to a full center focused on the death penalty, to now Project 39A, which focuses more broadly on criminal justice. So I wanted to start a conversation there. And in reading the forward to your forward to the book, it seems that your experience, and you recount the helplessness that you felt as a researcher researching on the socioeconomic profile of death row prisoners, where you couldn't really help them, and that was and you knew how much help that they required, but you couldn't really do anything because of research ethics. And it seems that helplessness has motivated much of the work that the work that you do today. So I was wondering if you could tell us a little bit about the journey so far. How did you and your team begin the work on the death penalty, the directions in which it has taken you, where you are now, what are the issues that the center is focusing on, and what plans you have for the future in terms of the issues that you want to focus on? I know that's a bunch of questions, but generally getting a sense of where you are on this journey.
Right. Thanks, Aparna, for taking your time out for this, and I really appreciate you doing this for us. And also thanks to LiveLaw for hosting this discussion. Yes, the book is in many ways culmination of some efforts that I think it's almost taken more than 5 years to work this book itself, and many attempts that were given up. And it is great to have Janvi finally write these stories in the manner in which she has written them. But yes, the journey with the death penalty research project just across the country, prisons and death barracks, and interviewing prisoners there and tracking families. So many of our students involved in that effort. And I think at some point, while there was I think you start with a lot of excitement and enthusiasm, and the kind of access that was given was unprecedented, sort of negotiating with each of the state governments. But I think very soon we realized that, I guess, and then you run into this common problem of, are you using your subject, right? Are you using your interview subject, right? And what do they have to gain for talking to you? And that expectation was always that, oh, here are these bunch of people who sort of come from Delhi, and they can certainly help us. and to repeatedly convey that in prisons across the country to prisoners who in extremely helpless situations. I think I think for me that was the part that I was most unprepared for, in terms of just feeling that uselessness as a researcher, saying what. And I think the challenge was also that somebody heading the research, how do you convey it to students, right? And the student researchers on, they are seeing this kind of frustration, poverty, and with the families particularly, right? And they were under very strict instructions not to offer any kind of assistance despite whatever they saw, either in terms of even food or clothing or anything of that sort. um, and I think that, I don't know if I would call it guilt, but certainly I think that was playing on our mind as well. That, it would be highly unethical to have seen and observed and documented all of this and published that report and not carry forward then what was obvious from that requirement. And as a law school, what did it mean for us as a law school where legal aid is a sort of a core part of the mandate of the university? What should it mean and what should it translate into? So yes, and I think it was with those feelings, I suppose, that we set up the work on the death penalty and pro bono legal representation and research. And then over time, I think many of the issues that we were confronting in the work on the death penalty, it was clear that there were other broader issues that were integral to the criminal justice system that needed work on. And therefore, then the transition to Project 39A and a much broader mandate on criminal justice issues. Yeah.
I want to come back to the question of the broader concerns with the criminal justice system in a bit, but to talk first about the book itself. I mean, this is a fascinating book and equally a heart-wrenching one, but it offers us a glimpse into the lives and circumstances of those who've had the death penalty imposed on them and their families, right? I was particularly struck by the fact that this volume is written with a general audience in mind. It's not for a legal audience, certainly not for an academic audience. But in your forward, you mentioned that in putting together this volume, or in putting together this work, I should say, you don't think that you will change anyone's mind on the question of abolishing the death penalty. I remember that in your report as well, or at least when you were presenting your report in one fora, you had made a similar disclaimer that this is not about changing people's mind on the question of abolishing the death penalty, but to give them a glimpse of what it means to be a death row prisoner. In that context, you had said that. And you end your forward by saying, and I'm quoting here, that the stories in this volume are written with the hope of making readers understand the people we want to kill. It is as much about the lives of prisoners and their families as it is about holding a mirror to society. Ultimately, it is an appeal to the humanity in all of us to know a little more about the people whose lives we want to take. Why do you think that's important? If you think
Yeah.
it's not going to change people's mind, why do you think it's important to tell these stories?
Yeah. I think uh, I think people I am completely open to the possibility, and I think that's what's generally happens on these highly divisive, polarizing issues. That change is not dramatic, change is not drastic. I think conversations need to happen in a very slow, incremental manner, and I think particularly on issues like this, law schools have to play that, or law universities have to play that role. And as researchers and as an academic, I see my job as presenting that information that for you to consider. It's not my job to prescribe what you should think after you read this, right? And that's for you to make up your own mind, and there'll be multiple influences on anybody looking at this. There could be things that you read in the newspaper, things that you watch on television, other views that you listen. My job is to present a certain um, um, reality that I have seen, and me and my team have documented. And I think it's a reality that doesn't get heard, right? And it's a picture and details that you don't hear. That when you think of that, we are so removed. I mean, the death penalty is as an issue. We are so far removed from it in the sense that it gets discussed and debated in the abstract. There are no faces, there are no voices. And I really do think that if people were to see and hear people on death row, right? And this is not to say that they must feel bad for them or they must sympathize with them. And sort of all throughout the book, in the 19 stories in it, you will see that the kind of reactions it evokes in you are very different. It's not one of, oh, just feeling bad for them, or it's and precisely was the struggle of the book, that these are very complex people, emotional people like you and me, right? And to present them as human beings, not as a TV debate, right? And that's the idea through the book. And I think we really need to think about, and it's very difficult, I think, and I uh, to for researchers like me to say how can we communicate to the public, right? How do we communicate our research in an effective way to the public without sounding condescending about it, right? And I think that journey has been hugely challenging, to prioritize it, to find resources, to find people, has been hugely challenging. It's easy, not and being in a university space, not to prioritize that, because I guess that's not what we're trained to think about
Yes.
as what we should do.
Um, so you've talked about the importance of telling these stories to the outside world, but I wanted to turn back to the question that we have in our title, which is to telling these stories to inside courtrooms, right? And when we read cases and judgments, and even when we look at appellate lawyers' files, the recounting of the of the case is in a very dry, in a very matter of fact manner, right? X happened, then Y happened, then Z happened, very logical and sequential. You don't really get a sense of the people behind the facts. And we are often taught in law school that this is how it should be, that we should look at the law dispassionately, that we should only look for relevant facts, set everything else aside, use only logic and reason to see whether the facts fit the law and how. But in such an emotionally charged domain as the death penalty, where, I mean, literally questions of life and death are being decided, I imagine a lot turns on how judges perceive the accused person, particularly when deciding questions like whether the person is capable of reform. I imagine it must be quite a challenge to tell the story of the accused person or a convicted person to the court. And I was just wondering what has been the experience of Project 39A, which has represented so many of the people on death row. How do you bring the stories? How do you bring uh, you know demystify, humanize the person whose story you're telling to the
Yeah,
court?
yeah. It's an incredibly challenging part of pro bono representation of death row prisoners. The law requires that mitigating circumstances about the offender be presented in court, while the law prescribes it just so simply in Bachchan Singh, and judges always say, "Oh, these are the mitigating circumstances," or "These no mitigating circumstances were present," or "I don't want to take into account any mitigating circumstances." And even when you read the mitigating circumstances, what do you read in judgments? Oh, this person was poor, this person has no prior history or has a dependent family. There is, I think it's there, as you rightly said, Aparna, that you don't get a sense of who this person is. And that very often is because that level of detail is not presented in court, right? And our law has not demanded that a certain threshold be met in terms of what information you are presenting about the offender, right? If you don't present anything, that's fine. We move ahead as though there is nothing, right? There is no legal conversation on what standard of information do you need to primarily do. And this kind of mitigation investigation is a very, I think lawyers are wholly unsuited for it, right? As you said, what we're trained is to, when you go and have the conversation, to say, okay, tell me what is relevant for this case. This is the evidence. What do you have to say about this? But stories don't get told like that, right? People don't trust you the moment you go, and just because you're representing them. It's a very complex dynamic, right? It's Why should anyone trust you with the darkest secrets of their life or the darkest aspects of their life, be it the prisoner or the family? Everybody feels a sense of shame, a sense of a fear of abandonment, that if those realities of their lives are spoken about, you will also abandon them, right? That you will judge them. And I think that process of building trust is a very complex and resource intensive process. You have repeated visits, talk about many things that have no relevance or might not have, and to build that trust is something that the league, in saying that present mitigating circumstances, the law really doesn't worry about how will it get present, who is going to collect it, and you need people who are trained, who are good at that. You need specialized social workers, you need mental health professionals who can then go and have these conversations and draw this information out and then learn to present it in court. And I think there, that interaction, that interdisciplinary interaction is a very tough one, even for litigators who are aware of this kind of discourse of mitigation investigations. Even when we brief senior counsels, right, it's not just about how we convince the court. It's about even the senior counsels who very, very generously appear pro bono for us, even conveying to them as to how should we tell this story. It's not like we have the answers, right? It's not that it's a sort of established practice that these stories of these prisoners who the court must sentence are presented in court, and the law requires it be presented, but nobody really has. I don't think we have invested enough time in saying how do we tell these stories. Is there patience to listen to these stories? Because yes, in law, it is very easy to say sentencing must be individualized. But to individualize it takes a lot of effort, and we really haven't thought through that. So it's at multiple levels, that sort of educating ourselves, educating our litigation team, educating the senior counsels, educating the judges, and sort of also invest, that the system has to invest in people who are professionally competent to do this kind of investigation to get these stories out.
So, what would a team of mitigation investigators look like? What,
Yeah.
what is a typical composition of a team? How would they go about sort of doing mitigation investigation?
Yeah, I mean, as I said, the first level of interaction, unfortunately, the prison rules are such that uh, you get access maybe 20 minutes in a week, right? And that too only for lawyers. And even the conditions of, and you have done so much of prison work yourself. You know the conditions of mulaqat, what they are, and how difficult it is to have the kind of conversation I'm alluding to. Again, there at an institutional level, there's no recognition that death row prisoners need to present all this information in court, and therefore there is that struggle just logistically to get information from the offender, then training the lawyer, because social workers are not allowed into prison. And again, there are variations, prisons being a state subject. Some prisons are more amenable to giving us more time or understand why it is being required compared to others. But I think ideally what should happen is that social workers trained in criminal justice systems, right, are the ones that need access, right? They are the ones, and ideally for us, are the social workers uh, uh, primarily are then accessing the family. The information is being brought out of prison through prison mulakats by the litigators, again, which is not the best practice, I would think. But for whatever that's possible in our system, they get that information out, and then begins a very in-depth investigation into their lives in terms of their families, friends, tracking back to when they were infants, or even the pregnancy of their mothers, right? In terms of looking at those circumstances, looking at the various people and circumstances and events that had an influence on them, bringing in mental health professionals where we think it's relevant to talk to these family members or the friends or acquaintances, talking to teachers, talking to former employers, colleagues. So it's like casting the net very, very wide. And it is to say, if we are to present sentencing information about this individual, what all do we need to know? And the truth is, we need to know everything, right? And then is the process of how do we then try and explain this individual to a judge or in a courtroom, and that's a separate process. So the first is a sort of this get everything you can, and very often those are subject to uh, the, the 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 realities of listing in the Supreme Court, right? So while there are the good practices on this might say that, oh, you should investigate each case for a year or 2 years. It's not possible in our system. It's not. You don't know when the case comes up, and when it comes up, you do what you can to present the best amount of mitigation information you can. But I think a whole host of, like, I think we had a case where we were dealing with, and then it's one of the stories in the book as well, on a case on human sacrifice, right? And sentence to death for human sacrifice. But then you need to get experts who can then contextualize the practice of human sacrifice in that particular part of India, right? So that's not either a social worker or a mental health worker. You need a sort of a very good anthropologist who works in that area, who understands the realities of that area, to contextualize what this person was doing, how they were brought up, and all of that. So it's each case presents its own need for experts. And my only point is, if the system is so invested in taking the lives of people, it should also be equally invested in creating appropriate procedures and having the relevant experts and allocating for that. Like, if you have a legal aid lawyer, the legal aid system just cannot appoint a lawyer and leave it at it. Right? That's not, the law requires something else, and you're not provided for it.
I wonder how much success you have in convincing judges that this material is relevant. I mean, I worry that based on your own report, right, that the overwhelming majority of people on death row come from very marginalized or very vulnerable socioeconomic circumstances, be it in terms of their economic capacity or their caste, their occupational background, what have you. And I just worry that given the biases and the prejudices in our system, presenting this kind of information might also be counterproductive in that um, in that judges are likely to feel that, if there's no sympathy. I mean, if you were not starting out with an empathetic outlook, not sympathy, with an empathetic outlook in the first place, which I assume our legal training at least doesn't really inculcate empathy in us. So I would not assume that of judges. And if you are not starting from a position of empathy, presenting this kind of information, is it, do you find that it is useful, or do you find that it is sometimes counterproductive? Is the
Yeah,
reception mixed?
I think it starts, I mean, the challenges start from a lack of patience with this kind of thing. Like,
Yeah.
what are you even doing?
Yeah.
Right? What is this? And that's both at the level of both the lawyers and the judges, right? How do you want me to go and say this in front of a judge? I mean, what am I saying, right? To then say, how do we mix the law and the facts? But you're absolutely right. We've had very mixed reception to this. There's been, with some judges, it's an appreciation that, okay, this is what the process should look like, and with some others, it's like, how is all of this even relevant? Why are you bringing these affidavits of the father and the mother and the school teacher and the garage owner where this person worked? Why should I care? How do I even know any of this? Of course, they would say all these things, right? Yes, and that's the battle, and it's starting. The battle is to say that these are due process requirements in sentencing hearing, right? And to connect that, and we are very far from convincing anybody on that point. But I think one thing, and I'd like your view on this, is that one worry has been, and with some judges, the response has been, what about victims, right? Right? And if you go down a similar road on victims, right? You could land yourself up in a very, very difficult position, right? And I was just wondering how you view this sort of, do convicts have too many rights, right? What do we need to sort of and and there's kind of sort of victim impact statements,
Yeah.
right? It yeah, it's a difficult question, really. I don't know how you view the.
No, I mean, I just think that this idea that there's some amount of balancing that has to be done, this metaphor of balancing between victims' rights and accused rights, as if a victim cannot be an accused and accused cannot be a victim. I mean, that these are two different silos and you need to balance the two. I mean, that metaphor has never made sense to me.
Yeah.
The other thing is, I mean, just our understanding of what justice requires for victims, right? Our constitution seems to suggest, and at least in one sort of version of our constitutional doctrine seems to suggest that what the victim is entitled to is uh, having their day in court, and if you convince well, not you, but the state convinces the court, then ensuring that there is a conviction. But in terms of sentencing, to say that the victim is entitled to a particular sentence, I just find that idea incredibly problematic, because then you are making sentencing depend on the vagaries of the individual victim, as opposed to a matter of the state inflicting violence and punishment, collective, the collective energies of the state going into the infliction of punishment upon the body and the life of an individual, and that's a very different view from that the idea that the victim should have a say in the kind of sentence that you should get is a very different view from this understanding of the state punishing on behalf of society, etc. Right? So I mean, I just find that we have to unpack our question of victim justice, the idea that of what the victim is entitled to very differently. And also, I mean, just to say that I don't think it's an either or. We don't do enough for victims. Anyway, our system fails victims on multiple levels. And the easy way out is to focus on things like on increasing the punishment, and we've seen this across the board in criminal justice, right? So increasing punishments and imposing the death penalty and increasing the number of cases or the number of offenses for which you have the death penalty. I mean, you know this better than I do, but India, of course, is bucking the trend, the global trend, in increasing the number of cases or offenses where we are going to impose the death penalty. And that, I think, that's a cop out. Right? That's a cop out, because you're not doing the hard work of ensuring that the system works for victims. So I mean, that's where I'm at. But just this idea of victims and accused are somehow sitting in a balance, and the balance is going up for victims and down for accused, and up for accused and down for victims. And that's never made sense.
So the system is broken at both ends, right? And as you rightly said, it's true that it's as difficult to go and file an FIR and get a proper investigation and a proper trial. That's as true as torture and wrongful convictions and fabrication of evidence. And this idea, as you rightly said, that we can solve one, we can gives more victims more justice by taking away rights of the accused. I don't know how. There are two problems that require very different solutions.
Very different solutions. And I think a lot of the work that you have done, and I know members in your team have done, particularly in the context of death penalty for sexual offenses, really brings this together, right? Where on the one hand, victims struggle to get themselves, get their FIRs registered, have a process that is sensitive, that treats them as dignified human beings, etc., etc. And on the other hand, you have this discourse which says that kill all rapists, that kind of blaring headlines kind of an approach. So I mean, but I think that leads me on to the next question that I wanted to ask about the sort of the kind of work that you've been doing on criminal justice generally. And of course, again, I know you've said this in the past, that one of the reasons why having the death penalty is problematic is because the larger criminal justice ecosystem in which it operates is completely broken. And again, like I said, I know you've said in the past that this is one of the reasons why you and your team have pivoted from just focusing on the death penalty to focusing on criminal justice system as a whole, because you see how broken the entire system is. So I was wondering if you could talk about some of the 2 or 3 of the main problems that you see as urgently requiring to be fixed in the criminal justice system.
I think torture-based evidence is especially, we have seen what it can do in trials,
Mm.
right? And this is irrespective of the question of, oh, did they actually do it or not? Morally, what is the truth, right? Irrespective of that, I guess as law people, we can appreciate the importance of how is this evidence gathered,
Right.
right? And the amount of, at least in our experience, the numerous cases that we've done, just the kind of torture-based evidence that comes into our system is very, very worrying. And even though I know we talk about abysmal conviction rates, but I think the picture would be even more abysmal if we looked at how much of it is torture-based evidence. Right? What can we do about it at the level of the investigation, at the level of how that evidence gets used, or why is this even allowed? What is Section 27 doing in this
Mm.
entire whole
Do you want
process?
to, I mean, just because we might have people here who are not familiar with the provisions of the law, do you want to say what Section 27
Yeah,
Evidence Act
okay. I'm just
is?
going to try and capture that. I mean, I guess the Evidence Act says confessions are not admissible, but
Confessions
uh,
to a police officer.
confessions to a police officer are not admissible. But 27 sort of, I don't know, there's a complicated relationship between that and 27. It says that part of your statement to a police officer, that as much as it leads to a recovery of evidence, can be admissible, right? Now, the way it works classically is that what is a confession? Okay, I killed X is inadmissible if I confess to a police officer. But if I say I killed X and the knife with which I killed X is behind the Sector 14 metro station here, then ultimately what happens is that a knife is promptly recovered from there. And when I say promptly, very deliberately, and that's why you see these signed statements on white paper and blank paper, and you might wonder why you are made to sign blank papers, and then that statement is then used against you, saying, okay, how did you know that this knife was there, or whatever? You have to explain the recovery, right? And therefore getting that statement out of you, or getting that statement out of you, becomes so important to get conviction evidence, right? So that's a huge thing. I think legal representation is a huge problem, and I think counterintuitively what we found was that, and even in the book there are stories of interesting stories about legal representation and interaction with a lawyer. uh, Counterintuitively, we found that about 65% of death row prisoners don't have legal aid lawyers in the trial court. They have private lawyers, and I think that has very
Mm.
interesting connections to what is happening in prison and the narratives
Yes.
around sarkari vakils in prison, and saying that do whatever you can to avoid them. But that in no way ensures that you get quality legal representation, right? This idea needs to be challenged, that legal quality of legal representation is a problem only in legal aid cases. I think that's just not true, right? At least that I think there's a larger quality of legal representation problem, and what are disadvantaged sections of our society able to access in the name of legal representation, even if it is private legal representation, needs to be thought about. Increasingly, I think there is a move in the direction of uh, using more science in investigations, in evidence, and I think that's a direction in which we are seeing that push. And I think there's a lot of dodgy science out there, so that's why we focus quite a bit on forensics, uh, DNA, bite mark, soil, sort of ballistics, all of that, toxicology, right? Digital forensics. I think there isn't enough expertise. I think science scares people, science scares lawyers, and therefore that immediately translates into just production of a report is unquestioningly accepted, and nobody wants to get into is the science reliable? What is that report? How do you cross-examine an expert? Who is an expert? And I think that's why we've invested quite a bit in that. Um, Mental health and forensics, mental health and the criminal justice system, again, is an area filled with a lot of misinformation and not enough knowledge between the lawyer and the judges. in terms of the insanity defense, in terms of competence to stand trial, what kind of mental health concerns are relevant for sentencing. So these are the range of things that I think cuts across the criminal justice system, but yet also are at the core of death penalty cases as well, right? So those are some of the issues that we look at. Yeah. So.
I mean, lots to unpack here, but one thing that struck me was, in the earlier part of our conversation, you were talking about the need for experts to come in when you're doing mitigation investigations, etc. And now you're talking about, how experts can be dodgy and it can be based on dodgy science. And I wonder if there's a contradiction here. On the one hand, we want more expertise in the system. On the other hand, you're very suspicious of expertise. Is that a contradiction?
I don't think it's a contradiction. I think expertise is needed, and I think it's the manner and the level at which you engage with that expertise, right?
Mm.
That just because it's expertise, it cannot be unquestioned, right?
Mm.
So if you have a DNA report from a lab, right, the sort of predominant approach to it is that, okay, that's a done deal. Oh, there is 100% match. Nobody really investigates that, right? Or what are the requirements of, what are the problems with the requirements of the insanity test, or right? What is it? What amounts to mental illness? How do you establish it? And or what is intellectual disability, and why is intellectual disability different from mental illness, right? All of these things, I think there is a need for the law to engage with expertise, with developments in science and in those fields. And I think that engagement is problematic. It's a very often an unquestioning acceptance. And because the science develops on its own, in its own way, and but the way it is to be made relevant for the law is a completely different ball game. And that interaction uh, is where the problem lies, really. And so therefore, yes, is expertise needed? Of course. And uh, but a very rigorous and questioning engagement.
Right. I mean, I think the problem also is, I mean, much as we buy into the myth of the objectivity of the law, we definitely buy into the
Certainly,
myth of the
yeah.
objectivity of
Yeah.
science, right?
Science, yeah.
And there's so much evidence to the contrary,
Correct.
particularly how science has been used in trials, and how
Yeah.
science has been disproved over time, and science that was used to convict people, to racialize people, to
Yeah.
colonize people,
Yeah.
and including to racialize and colonize ourselves in our
Yeah.
context. um, and with that background, we still believe in somehow
Yeah.
in the capital O objectivity of science.
Mm.
So perhaps that's also a problem. I mean, I know we're running out of time. I had one final question to ask, and then maybe we can open it up for questions. But I mean, you've referred, at least early on in the conversation, you were talking about the fact that Project 39A is located within a university, and a public university at that. And so it's a research center, it's a litigation clinic. It is in many ways doing policy advocacy around issues in the criminal justice system. I wonder, what are there challenges to that? What are the challenges to being a research and clinic based sort of center in a public university in India
Yeah.
today?
Yeah. Yeah, I think at multiple levels on that. I think um, just in terms of, um, I think the good part is that it's the work comes with a sort of automatic or sort of fair degree of credibility because it's being based
Mm.
out of it's based out of a university. There is engagement with institutions that is far easier because you're based out of a university, and
And a public university at
and a
that.
public university at that. So there are, I mean, there are certainly, and I think we've received incredible cooperation from some of the institutions across the country on this. But I think there are also certain difficulties of operating within a public university space in terms of just sometimes the pace frustrates you, right? The processes frustrate you. Um, But I think just in terms of the support of the work that we've got for this, I don't know, uh, uh, I have been surprised, let me just say, and the sort of the former vice chancellor and Professor Ranbir Singh and the current vice chancellor Shridev Rao. I think universities. I think it's not easy for a university to make allowances for this kind of thing, because I think there's an acknowledgement that because of this, teaching suffers, right? And then I think in resource-starved institutions, they're not being able to teach, and I think that's something that I personally am acutely aware of. That I teach a lot less now than what I used to, so there is that cost. But I think there is I think an important educational perspective to being located within a university, right? And working with students, be it the research project or as interns on various other projects that we're doing now, or on the litigation cases, not just students from NLU Delhi, from all over. I think that learning of and I think classroom learning is incredibly important. I think theoretical learning and reading is incredibly important, but it is important then to try and see how all of that applies in the current realities of our world and our society. And I have had, I mean, I think it's been a very satisfying experience to see how students interact with that classroom experience, and then this kind of experience working with the criminal justice system. Of course, some students have reacted in terms of, I think, I mean, different students react very differently. For some, it's like uh, nothing is going to happen, so may as well not get into this. They find it really demanding in terms of just the darkness that they see and the hopelessness that they see, and they just don't want to engage with it. And I completely understand. For others, it is a challenge. It is a frustrating experience. It sort of tries and pushes them in direction that they want to go in terms of their careers. But I think at the end of the day, I think uh, it's very satisfying to be able to give students that exposure as well, and sort of the young colleagues who come to work here as well. It's been satisfying to create that space, and I think the university has done very, very well to um, nurture that space and give the support that is required. Yeah.
Right. No, I absolutely agree with you. Having run a center at NLU Delhi for many years, completely agree with what you're saying, and had similar experiences, particularly with respect to doing work in prisons, where though that kind of work is particularly demanding also on students, and seeing how students react to those spaces has been, and sort of learn from that experience, has been a very, very rewarding and an enriching experience for me too. We have some questions in. Let's sort of move to the question and answer part of this conversation. So we have Anil Singh, who's asking, the principle of res gestae was perhaps not taken care of while drafting Section 27. And then he goes on to say, can investigation in present times be conducted without the aid of science? I don't know if you have anything to offer on the principle of res gestae, but perhaps you could definitely speak to the question of, again, investigation with the aid or without the aid of science.
Yeah. A lot of investigation in present times happens without science, right? And that's one problem, right? That's one end of the problem, right? That a lot of it is unscientific investigation. But as Aparna was rightly saying, we can't glorify science either, right? And I think the problem is that we've seen this kind of how it can go so wrong. And if you read sort of the judgment in Selvi, right, you see that kind of the truth serum and all kinds of dodgy science that creeps in. And I think we really need to be careful about what science we use and how we use that science in a matter that is in manner that is relevant for law.
Perhaps you
Right?
could give an example, Anup, of the kind of sort of, some example of a kind of problem that you've seen with sort of forensic science, which is considered to be, I don't know,
Bite
state of
marks.
the art, right?
Bite marks.
Right. Okay. So If you could
right?
just tell us a little bit
Yeah,
about bite
I mean,
marks and their
yeah, sort of this idea that bite marks are unique to each of us is junk science, right? And I think continues to be used, right? Or um, um, right? And I think uh, there is no question. I mean, we just haven't said um, is the science reliable? That's the first question to ask, right? And then to see, okay, can we use it in a particular case, and what are the problems that arise from this kind of bite mark that you have in a particular case? And there are some fascinating examples of this in terms of uh, this disagreement. If you do a sort of blind review on this disagreement whether it is even a human bite mark, right? How do you even establish that something is a human bite mark, right? And there are studies in different parts of the world sort of that question all of this, but we don't, and in our system we don't even have the that discussion just hasn't happened, right? On DNA evidence, right? On this, and I think again studies, same set of DNA evidence sent to 20 different experts, whether it can be said to whether a certain accused can be excluded from the category of suspects or not. Multiple opinions, right? That different people send on the same set of evidence, and these are all well documented, peer reviewed studies, right? But that conversation has just not happened here in terms of uh, uh, what are the questions that we need to ask in respect of scientific evidence um, um, in our country. So we just hasn't that just hasn't happened.
So I hear you as saying that you're not saying you're not anti-science. You're not saying that don't use science. In fact, perhaps use more of science, but use reliable science.
Reliable.
Don't use junk science, and question it. Right? Question. Have an inquiring attitude both towards the science and to its application to a
And
particular
as lawyers, you have
application.
to learn some amount
Yes.
of that science, right?
Yeah.
As a defense lawyer, if you are confronted with DNA evidence, right? I mean, there's no. I mean, yes, there is a need to have access to expertise as well, undoubtedly. But unless you, as a defense lawyer, learn something about it, you really don't know what questions to ask or how it is to be applied in your case, or how to challenge that evidence, right? Or how to challenge bite mark evidence, right? There's one thing to say, oh, there's to challenge bite mark as a science, and quite another to say, okay, in this particular case, how do I challenge the bite mark evidence in this particular case, right? So yeah.
Sure. We have a question from Shubham, and Shubham is asking, how is it fair to glorify the lives of prisoners convicted of death penalty? Anup, your take on that?
Yeah.
Do you think this work amounts to glorifying the one? Do you think it amounts to glorifying the lives of death row prisoners? And second, if it does, do you think it's fair?
Um, I don't think it's glorifying. I think if you read if you read the book, as I said, you are not going to come away feeling that their lives are glorified in any sense. They're not being. Uh, but I think what is being done for sure, and I'm sort of very unapologetic about that, is that your perception about people who commit crimes uh, is being made more complex, right? You're being uh, uh, material
Confronted.
is you're sort of being confronted, right? With now, if I what do you make of this? And that's all. It's only asking you a question. What do you make of this, right? I think it's saying it's asking you to just pause a little and think of what do you think of people who commit crime, right? What do you imagine their lives to be? Who do you think they are? And I think you will see that they are no one thing, right? They are no one type of individual, right? Uh, they are as boring and as complex as any of us, right? Or as complicated as any of us, right? And that's to say, what does that do to your perception about them? And it's just leaving you with that question, right? Uh, there is certainly no, I would assume, glorification would mean that that there is a certain celebration of that life, right? And I don't think that's what it's. I think the idea is to get their lives out of obscurity and present it to them in a manner that you can consider. Again, there's no inclination in the book, as Aparna will tell you, to think either way with any of the stories.
No, I also thought, I mean, it's something that you mentioned in your foreword, that Janvi mentions in her author's note, that when we hear of horrific incidents, we tend to start viewing the accused persons or the convicted persons only through the lens of that event.
Yeah.
Right, and that reduced their entire life to that one single event. And what I thought that this work does is rounds out the picture to say, okay, who are these people, and then how do you look at them? And I mean, I am again can't let go of my lawyerly training, so my mind immediately goes to the fact that, you know, if you present all of this to a judge, so that the judge is not just looking at the brutality of the crime or
Exactly.
the horrific nature, you know, the Machi Singh kind of standards, but is looking at this as looking at the person as a you know, from a 360-degree sort of view, is more likely to see the possibilities of reform, the standard
Yeah.
that Bachan Singh lays out for us,
Yeah.
the possibilities of reform, than if they just view them through the lens of that one single event.
Yeah.
So, I mean, that would be my take on the need and the importance of
Yeah.
having these stories out there. Apart from the fact that, I mean, this book itself is, of course, geared towards a more sort of public audience. And for people to think about the lives behind the stories that you hear in the
Yeah.
headlines. Aditya has a question for you. Your thoughts on laws which are not based on science, like the NDPS Act?
Aditya, I'm not sure what you mean by laws not based on science, like the NDPS Act. I wonder if you're referring to the conversation on sort of to decriminalize certain substances, and given the kind of conversations that are happening on that, I'm not sure on whether if that's the conversation. But Aparna, do you? I don't
I
know.
mean, I would think so. Yeah, well, there are different ways in which the NDPS Act you know, intersects with science or the lack of it, right? One is just the entire sort of approach to drug offenses, and the heavy hammer approach that we have to drug offenses is very much caught up in sort of geopolitics of the drug trade and the US war on drugs and the agenda that is then pushed by the US. And that's one reason why we've got a fairly draconian NDPS Act, which of course then goes on to um, uh, to im- to influence. The NDPS Act then becomes a prototype in many ways to influence your Tata, Poda, not Tata, but many of your terror laws, and we pick up from, you know, our experiments in the NDPS Act elsewhere. So that's one way in which the draconian nature of the NDPS Act is not based on some sort of necessarily scientific sort of rationale, but
and just
yeah,
yeah.
scientific in that
Sorry,
sense. Yeah.
yeah.
No, but just to say that the other thing is, of course, the classification of offenses in the Act, your small quantities, medium quantities, commercial quantities, intermediate quantities, commercial quantities. Again, there's no necessarily scientific rationale, right? So, I mean, it's not based on how potent that drug is. It's not necessarily based on any of these conversations, but on matters of expediency. And again, very much rooted, the ideology of the NDPS Act is very much, you know, punish and incarcerate for as long as you can, and do whatever it takes to sort of frame the act in that way. So I could see the relevance of that question in terms of that the NDPS Act is not necessarily based on science. And of course, in the way that you mentioned, that do we really need to criminalize the possession and the use of certain of these substances?
And to also think that substance dependence and substance abuse, I think the science on it is that it is a public health question. I mean, it's a health question, right? It's not there's no point looking at it through the prism of criminality, and to sort of adopt a public health approach to it rather than a sort of a law and order approach to it. I think is also a sort of a, as Aparna was saying, that it gets sucked into that larger conversation on war on drugs and drug routes and all of that. Certainly, and then the science of it just gets left out. Yeah.
I think we have time for one more question. Sahil wants to know what happens to the family of the victim after the death sentence, after the
Right.
person is sentenced to
Yeah.
death.
Oh, interesting question. Very little work on that, Sahil, in terms of again the I think we need to understand that uh, victims' approach to justice, and Aparna was also talking about it. What does justice mean for victims? Is not a homogeneous narrative. It's not that all families of victims of crime want the death sentence, right? Yes, there there could be people who want the death sentence for the offenders, and there are those people who would not want the death sentence, or who would view questions of justice very differently, right? And I think it is very convenient for the sort of political narrative on punishment, and for the state to say, oh, we are doing this for the victim, that we want to increase punishments. I'm not talking of just the death sentence, right? Of any punishment, we want to keep increasing punishments because that's what victims want. But I think what victims want is a lot more complex area, right? And I think there's some interesting work on one set of reactions to the particular context of death sentence, and I think this is in the context of the Atlanta bombings. I think this work on families, sort of work with empirical work with families on saying them wanting the death sentence and wanting to see the execution happen, um, and then for a significant number after the execution happens, uh, it is then that they have to start to come to terms with their loss, right? And then it's a very complex narrative there that it's also that for some people, and again, I just want to be, even at the risk of repetition, there's no, I don't think there's any common narrative possible of what victims want or what victims experience, right? And but one interesting perspective I got from that work was how then seeking the execution of the offender is a way to cope, right? And then once the execution is carried out, and then I think that was Timothy McVeigh in that case, and then once McVeigh's execution is carried out, then there were some families. Then you then are confronted with um, what now, right? And then having to come to terms with that loss. Then, so these are very complex areas. I just think we don't give these are, I don't think these are questions that can just be decided on shrill television debates. It requires a lot of consideration and calm, and these are very complex human issues. And I don't think we should pretend to know them or simplify it. And yeah.
I mean, you know, I was reminded of reading a study that was carried out in Britain before and after the death penalty was
Yeah.
abolished.
Right.
And the study there said that, you know, when the death penalty was on the cards, when people were victims of a crime or their, you know, family members were victims of a crime, the demand was always for the death penalty. That was what you saw as justice because that was the harshest punishment that the system offered. And once the death penalty was taken away, then slowly, and it happened gradually, it's not as if something that happened overnight, people's demand for justice changed, their understanding of what is justice changed to whatever is then the harshest punishment that the system offers. So in some senses, the idea that death penalty is justice is also rooted in the fact that we have the death penalty.
Have it.
If we don't have it, for example, if dismemberment, public dismemberment is not on the cards, people will not call for people may still call for public dismemberment but not very seriously expect that public dismemberment will be carried on because you don't have it on the on the cards. But if you do have it, tomorrow you might have a demand for public dismemberment. So in some senses, it's also that the options shape our understanding of what justice requires. Anup, it's been fascinating as always. I think we have to bring the session to an end here, but I really enjoyed having this conversation.
Thank you so much,
And
Aparna.
Look forward to reading more about the work that you all are doing. And thank you everyone for joining in. Thank you
Thanks, everyone.
LiveLaw,
Thanks, everyone.
for organizing this conversation. And I think a recording of this will be available on YouTube for you to view at a later point as well.
Right. Thanks.